Welcome to the Lowenstein-Sandler podcast series. I'm Linda Bennett, chair of the Insurance Recovery Group at Lowenstein-Sandler. Before we begin, please take a moment to subscribe to our podcast series at lowenstein.com/podcast or find us on Amazon Music, Apple Podcasts, Audible, iHeartRadio, Spotify, SoundCloud, or YouTube. Now, let's take a listen.
Welcome back to Don't Take No for an Answer. I'm Eric Jesse, a partner in Lowenstein-Sandler's Insurance Recovery Group, and I'm pleased to be joined by my colleague, Alex Corson, today. So we're going to return to an issue we looked at in August of last year, which is the 3M's self-insured retention decision that's in the Delaware state courts. If you listen to our earlier episode, you'll recall that the Delaware Superior Court had held that 3M was required to engage in a pointless formality to realize the benefits of its subsidiaries' legacy insurance policies. Now, the Delaware Supreme Court has weighed in, and we're here to walk through the main takeaways and also share some practical tips to help policyholders avoid the type of hyper-technical defense that was raised in this case.
Thanks, Eric. Yeah, there's a lot to unpack here, especially given how close the decision was in the Supreme Court. Spoiler alert.
Absolutely. Let's start by just providing some background for anyone who missed our last episode. All right, so back in 2008, 3M acquired a company named Aero Technologies. The legacy Aero commercial general liability policies had a $250,000 per occurrence self-insured retention, and the policy language stated that the retention shall not be reduced by any payment made on your behalf by another.
Yeah, so that uncommon language from a standpoint of our modern sensibilities was the crux of the dispute. And when you fast forward to a products litigation that started years later, a 3M and not Aero itself paid approximately $372 million in defense costs and then sought reimbursement under the Aero policies. Well, the Aero policies insurers denied on the grounds that Aero, the named insured, had not paid the defense costs itself, but rather 3M, its parent, had done so. And as we discussed last time, the Superior Court sided with the insurers, holding that only the named insured Aero could satisfy the SIR under the plain meaning of that policy language that you just read. And the court was unmoved by the argument 3M advanced that this was a poor, pointless formality. Who cares where the money came from, which bank account it was in the name of? It's all 3M at the end of the day, they said.
Yep, absolutely. All right, so Alex, here's the big question. What did the Delaware Supreme Court do with that Superior Court ruling?
Well, so where things get interesting. The Supreme Court affirmed the decision in a deeply divided 3-2 split. The dissent was almost half as long, if not more than that, than the majority opinion. The majority opinion focused on 2 points. Again, they agreed with the insurer and the Superior Court. Policies that are not ambiguous. You means you. In this case, you is the named insured, so payments made by 3M, they fall outside the SIR's condition that the payment be made by the named insured. Agreed that the words payments by another was unambiguous, reinforced that. The court also had some interesting reasoning, turning on the difference between a self-insured and a deductible. Now, in a lot of our cases, a self-insured and a deductible are functionally the same thing, right? Both amounts represent money that the policyholder is required to pay before the insurer. But the court explained that unlike a deductible, a self-insured retention operates as a condition precedent because the insured must pay the SIR, the self-insured retention, before the insurer's obligation under the policy is triggered, whereas a deductible is an amount that the insurer must pay from $1 subject to the right to recoup that from the insured. So, in other words, true deductible policy, the insurance company pays from $1. They have a right to recoup the deductible, whereas the way that the wording in a true self-insured retention policy works, they don't have any obligation to pay until after that's been satisfied.
Yeah, Alex, I think the deductible can also eat into the policy limit as well, if it's a deductible policy as well. But we digress.
Precisely, yes. Many distinctions, but that was the one that the court was focused on. And 3M advanced another argument that the court was not convinced on. There was a maintenance clause, they called it, which is a provision making clear that that the insured doesn't get off the hook because of a bankruptcy or insolvency of an insured. And the majority said, look, that's not what happened here. The subsidiary remains solvent. The problem was that the self-insured retention clause, as it was worded in the policy, it wasn't satisfied. So to use the court's words, these so-called savings clauses say nothing about crediting the payments of a third party to the satisfaction of the SIR.
I think it's really important to recognize that this was a close call. You have the dissent that was authored by Justice LeGrau and joined by Justice Traynor, where they strongly disagreed with the approach that the majority took here. They argued that the majority was elevating form over substance and that the strict reading of the policy language led to a forfeiture of coverage, even though the risk was actually borne by the policyholder's corporate family and the insurer's risk profile didn't change here. The dissent also emphasized that Delaware law avoids interpreting insurance contracts in a way that would result in a disproportionate forfeiture, especially when the policyholder's reasonable expectations and the realities of modern corporate structures are at stake.
Exactly. The 3-2 split demonstrates that even when the words on the page are crystal clear, as they arguably were here, courts are reluctant to enforce these types of hyper-technical conditions that, as 3M said so many times, amounts to a pointless formality. The dissent's view recognizes that the practical reality in this case is that the insurance company was not being asked to pay a single dollar more than they had agreed to pay. And ultimately, they enforced what I would call a windfall recovery for the insurer based on what amounted to an internal accounting decision by the policyholder, which bank account should the amounts be paid to defense counsel. So,
Yep. Form over substance, indeed. All right, so that's the legal landscape. So let's shift and talk about practical implications, which we often like to do here on Don't Take No. The key lesson for risk managers and in-house counsel is this. The words matter, which is a very common theme for us here on Don't Take No for an Answer. If your policy says only the named insured can satisfy the SIR, the 3M decision shows that courts will enforce that language, however pointless that requirement may seem. Again, just review policy language carefully. Always read your insurance policies thoroughly, paying attention to definitions, conditions, and any requirements for triggering coverage.
Yeah, additional takeaways beyond the words matter. We talked last time about the importance of doing your due diligence in an M&A deal. Oftentimes, M&A deals, the legacy subsidiaries might not have cash on hand or active bank accounts. In that type of situation, this condition in 3M might be a real problem. So making sure that in deals, you're doing a thorough review of the target's insurance policies, get copies of the policies. Don't just take a certificate of insurance or a summary. Take a look at that language, especially if that target has potential legacy liabilities. And I think that looking after 3M, that type of non-market can't be satisfied by another language should be on every deal lawyer's due diligence checklist. As we talked about last time, also conduct regular policy audits. Just make it a habit. Periodically review your program. Look at new policies that you're acquiring, not just in a deal, but also as a regular course. Make sure that you have the gold standard, especially if you're paying a pretty penny in premiums. I think that if market standard language, which is allowing the satisfaction of self-insured retention by any source, had been used in the policies in this case, that the whole case never would have happened, right? 3M would have just satisfied that. And then lastly, there's a hidden lesson to be learned here, which applies, I think, across the board, not just to 3M case, and that's submit your bills for credit early against the self-insured retention. Part of the problem here is that 3M had paid hundreds of millions of dollars before the question was called, had they satisfied the SIR. And so they didn't get the carrier's position until $372 million in. On every case where there's a self-insured retention, we always counsel policyholders, get those bills submitted, get the carrier's position on whether the self-insured retention has been satisfied. You may face cuts, you may face denials, you may face something hyper-technical like this. And even if it was impractical or impossible for 3M to have reviewed the policy language or spotted this issue, given its sort of unusual language, getting the carrier's position and getting that credit after the first $250,000 might have avoided a big dispute over the technical language.
Absolutely. All good advice and things to think about. All right. So I think in summary here, the Delaware Supreme Court didn't really create a new rule, but it did highlight a risk. 3M assumed that it did not necessarily matter where the money was coming from, especially because it was in the corporate family, and ultimately paid the price here. Although this was a 3-2 decision, and many courts would agree with the dissent about the need to avoid forfeiture, even if the majority adhered to the strict policy language in the case.
Right. And an assumption and overconfidence, I think, can be a policyholder's undoing on a claim like this, right? It seemed clear as day to 3M that the self-insured retention and who has to pay it, that's a pointless formality. Look, the insurers felt differently, and they convinced the majority of the Supreme Court of Delaware that a self-insured retention is a bargain for, condition precedent, and you got to satisfy that. This is something that our premiums are based on. That's where the court went with this. So recommend that policyholders give careful thought to the language in the policy early in the claims process, and if necessary, engage coverage counsel to help spot issues early on. You don't want to find yourself in the same position as 3M, where you're several $100 million in on defense costs, and then you can't recover because they were paid from the wrong bank account.
All right. Thank you, Alex, for a riveting discussion as we continue to fight the good fight here on Don't Take No for an Answer. I hope our listeners found this case to be informative and a cautionary tale. So until next time, don't take no for an answer, especially when it's hidden in the fine print.
Thank you for listening to today's episode. Please subscribe to our podcast series at lowenstein.com/podcast, or find us on Amazon Music, Apple Podcasts, Audible, iHeartRadio, Spotify, SoundCloud, or YouTube. Lowenstein Sandler podcast series is presented by Lowenstein Sandler and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of counsel. Prior results do not guarantee a similar outcome. Content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.